For 48 years, every parole board that heard his case offered him the same deal. "Admit what you did," they told him, "and we will let you out." He had not done it. He had been in a different state, 700 miles away, playing pool with friends on the afternoon of the crime. 4 people had seen him there. 4 people had signed statements confirming his alibi before the original trial. 4 people had been ignored by the jury that had sentenced him to death. He had refused at every one of the parole hearings to say that he had done it. He had refused even when the refusal had kept him in prison another 5 years. He had refused when it had kept him in prison another 10. He had refused across every decade of a sentence that would eventually, when he walked out in July of 2023, set the American record. His name was Glynn Simmons. He walked out of the Oklahoma prison system at the age of 70. He had been inside for 48 years, 1 month, and 18 days. It is, according to the National Registry of Exonerations, the longest documented wrongful incarceration in the history of the United States. This is his case. It is also the case of an officer's investigation file that had contained, from 1975 forward, the identification of 4 different men by the surviving witness, an identification that the Edmond, Oklahoma Police Department had chosen not to disclose to the defense. That file sat in a metal cabinet in the Edmond records room for 48 years. It was finally found by an attorney with the authority to request it in 2022. By the time it was found, the man who had been sentenced because of its concealment was 69 years old and had recently been diagnosed with cancer. On the afternoon of December 30th, 1974, 2 men walked into a liquor store in Edmond, Oklahoma, a suburb of Oklahoma City. One of them was carrying a handgun. They robbed the register. In the course of the robbery, they shot the cashier, a woman named Carolyn Sue Rogers, killing her. They shot a customer, a woman named Belinda Brown, who had been in the store at the time. The bullet entered Brown's head. She survived. She was, by the medical account of her recovery, able to recall only fragments of what she had seen. She had been in the store for approximately 15 seconds before the shooting. She had been in the store for another 30 seconds during it. She had, during that 45-second period, looked at the faces of the 2 men who had come in. The Edmond Police Department began its investigation the same afternoon. They had a surviving witness. They had physical evidence from the scene, shell casings, a partial boot print outside the back door, a description of the getaway vehicle from a motorist who had seen it pull away. In the first days of the investigation, no suspects emerged. The investigators, on the basis of the physical descriptions Brown had been able to provide during her recovery, began to circulate photographs of men with prior arrests in the Oklahoma City area who matched the general description. In February of 1975, a man named Leonard Patterson was arrested in connection with a separate series of robberies in the Oklahoma City metropolitan area. Patterson, under interrogation, made statements that the Edmond police interpreted as implicating other individuals in the liquor store case. Among the names that surfaced during the interrogation of Patterson was the name Glynn Simmons. Simmons was 22 years old. He had been born in Harvey, Louisiana, a small town across the Mississippi River from New Orleans. He had moved to Oklahoma City in the early 1970s to live with an aunt while he looked for work. He had, at the time the Edmond Police Department's attention fell on him in early 1975, been in Oklahoma for several months. He had no prior convictions in Oklahoma or in Louisiana. On December 30th, 1974, the afternoon of the liquor store robbery in Edmond, Glynn Simmons had been in Harvey, Louisiana. He had been at a pool hall playing with 3 friends. 4 people had seen him there across the course of that afternoon. 4 people would, over the following months, give sworn statements to that effect. The arithmetic of what Edmond was proposing when they named Glynn Simmons as a suspect in a robbery murder in Oklahoma in late December, would have required him to have been in two places 700 miles apart within a single afternoon. That impossibility did not, in the course of the investigation that followed, dissuade the Edmond Police Department from pursuing him. In the early weeks of 1975, the Edmond police conducted a series of 8 lineups in front of the surviving witness, Belinda Brown. The lineups were photographic. Brown, recovering from her injuries, was shown arrays of photographs over the course of multiple visits to the police department. At each visit, she was asked to identify the men who had been in the liquor store on December 30th. In the first 7 lineups, Brown identified 4 different men, none of whom was Glynn Simmons. In the 8th lineup, she identified Simmons. The official police report that would be introduced at Simmons's trial described the 8th identification as a positive identification of the defendant by the surviving witness of the crime. The reports from the first 7 lineups, the reports documenting Brown's identification of 4 other men, were not included in the materials turned over to the defense. They remained for the next 48 years in the Edmond Police Department's internal records. At his trial in the spring of 1975, Glynn Simmons presented his alibi. He presented the 4 witnesses from the Louisiana pool hall. He presented their testimony, given in a Louisiana courtroom by deposition because of the difficulty of transporting out-of-state witnesses to Oklahoma City on short notice. The prosecution presented Belinda Brown's testimony. She identified Simmons in court as one of the men who had been in the liquor store on December 30th, 1974. The prosecution did not mention that Brown had, in 7 prior lineups conducted by the same police department, identified 4 different men. The jury convicted Glynn Simmons of first-degree murder. He was sentenced to death. In 1977, his death sentence was commuted to life in prison without the possibility of parole, following the United States Supreme Court's ruling in Furman v. Georgia, which required states to restructure their capital sentencing procedures. The commutation did not overturn his conviction. He remained, as he had been since the afternoon of his sentencing, a man in the Oklahoma prison system serving a sentence for a murder he had not committed. He was 23 years old at the time of the commutation. He would not be a free man again until he was 70. Between 1977 and 2023, Glynn Simmons lived at a succession of Oklahoma State correctional facilities. He worked, he read, he wrote letters to his family in Louisiana. His mother, who had been in her 40s at the time of his arrest, died during his incarceration. His father died. His aunts and uncles, who had raised him in Harvey, died. His siblings, who had been young adults when he had been taken, became middle-aged and then older-aged, and made lives of their own without him in them. He had, over the course of the 48 years, a series of attorneys who worked on his case pro bono or at significantly reduced rates. He filed habeas corpus petitions. He filed motions for reconsideration. He filed requests for access to evidence. Most of these motions were denied. He was offered parole at intervals of several years across the latter decades of the sentence. Each parole hearing was, in its structure, a negotiation. The board, operating under the Oklahoma statute governing eligibility for release from a life sentence, would consider whether the inmate had demonstrated, among other things, an acceptance of responsibility for the crime of conviction. Glynn Simmons refused, at every one of those hearings, to accept responsibility for a crime he had not committed. Each time he refused, his parole was denied. The refusal meant that he remained incarcerated for additional years beyond the earliest dates at which, had he been willing to say what the board wanted to hear, he might have been released. The pattern was, in the aggregate across the decades, the defining fact of his life. He had been told he could be free. He had been told that freedom was contingent on a statement. The statement was a lie. He had not said it. He had stayed. In January of 2023, Simmons's newest attorneys, a pair of Oklahoma lawyers named Joe Norwood and John Coyle, who had taken up the case after becoming aware of the alibi evidence that had been introduced at trial, filed an amended petition for post-conviction relief. The amended petition included, for the first time in the legal record of the case, documentation of the original 1975 police report about Belinda Brown's identifications. It had been obtained, in the months preceding the filing, through a records request that had taken years to process. The report showed that Brown had identified 4 different men across 7 lineups before she had identified Simmons in the 8th. The report had, throughout the 48 years of Simmons's incarceration, been in the Edmond Police Department's custody. It had never been turned over to the defense. On April 14, 2023, the Oklahoma County District Attorney at the time, Vicki Behenna, filed a motion in support of Simmons's petition. Behenna had, before her election as district attorney, served as the head of the Oklahoma Innocence Project. She had spent a career identifying wrongful convictions. She was now, in her capacity as the chief prosecutor of Oklahoma County, asking the court to vacate a conviction obtained by her own office. On July 20, 2023, Oklahoma County District Judge Amy Palumbo granted the motion. She vacated the 1975 conviction. She ordered a new trial. 2 days later, on July 22, 2023, Glynn Simmons walked out of the Oklahoma Department of Corrections after 48 years, 1 month, and 18 days. He was 70 years old. He had, at the time of his release, been in Oklahoma state custody for more time than most Americans alive at the time had been alive. On September 11, 2023, Behenna announced that the district attorney's office would not retry the case. The original evidence had been compromised by the suppression of the lineup reports. The surviving witness was deceased. The alleged co-defendant had long since been released. There was no realistic path to a new conviction. On December 19, 2023, Judge Palumbo issued a declaration of innocence. She wrote in her ruling that there was clear and convincing evidence that Glynn Simmons had not committed the crime for which he had been convicted. The Oklahoma State Wrongful Conviction Compensation Statute provided, at the time of Simmons's exoneration, a maximum award of $175,000 regardless of the length of the wrongful sentence. $175,000 divided across the 48 years of the wrongful incarceration amounted to approximately $3,645 per year of freedom taken from him. In August of 2024, the Edmond City Council, responding to a civil suit filed by Simmons against the city, approved a settlement of $7,150,000. The settlement represented the city's acknowledgement of the original investigation's suppression of evidence. Simmons also filed a civil suit against the Oklahoma City Police Department, which had been involved in the original investigation. That suit was, as of the publication of this recording, active. The original prosecutor in the 1975 trial, a man named Mildfelt, submitted letters to the Oklahoma Pardon and Parole Board during the later years of Simmons's incarceration. He had, by the time of those letters, retired from prosecutorial work. In the letters, Mildfelt stated that if everything that had later been learned about the case had been known at the time of the original trial, the verdict might have been different. His letters did not, on their own, produce Simmons's release. They had been filed. They had been read. They had, across the years, not changed the outcome of any of the parole hearings. The surviving co-defendant of the 1975 trial was a man named Don Roberts. Roberts had been tried alongside Simmons. He had received the same sentence. He had been, like Simmons, sent to the Oklahoma prison system. Roberts had been released on parole in 2008 after serving 33 years of his life sentence. Unlike Simmons, he had at some point agreed to the form of admission that the parole board required for release. He was, at the time of Simmons's 2023 exoneration, a free man. But he was not, in any formal sense, an exonerated man. The Declaration of Innocence that Judge Palumbo had issued for Simmons in December of 2023 had not extended to Roberts. Roberts had not been declared innocent. He was, in the legal status he carried into the rest of his life, a paroled convict. He was not eligible for the wrongful conviction compensation that had been paid to Simmons. He was not eligible, by the same legal status, for the Edmond civil settlement. Roberts, in a 2024 interview with a criminal justice news outlet, described the position he occupied.
"Sometimes I feel free," he said, "and then I walk outside and I realize, no, you're not free." Glynn Simmons, in the months after his release, returned to Louisiana. He visited the town of Harvey, where he had been in December of 1974. He visited the graves of his parents, who had died without seeing him outside of a prison visitation room since he had been 22 years old. He also, within weeks of his release, began treatment for cancer. The diagnosis had been made in the final year of his incarceration. The treatment, begun after his release, continued into 2024. He appeared during the year after his release at a small number of public events. He spoke quietly. He was, in the interviews he gave, measured about what had happened to him. He did not, in any of those interviews, use the word anger. He used the word tired. What had sustained him, he said, through the 48 years, was the refusal. If he had said what the board wanted him to say, he told one interviewer, he would have been out earlier. He might have had more years with his mother. He might have had more years with his father. He might have known his nieces and nephews as they had grown up, rather than as adults he was meeting for the first time. But the saying, he said, would have meant that he had admitted to killing a woman he had not killed. It would have meant that the woman's family, the Rogers family, would have continued to believe that the right man had paid for what had happened to Carolyn Sue. It would have meant that Belinda Brown, the surviving witness who had testified at his trial and who had gone to her grave believing that she had correctly identified the man who had shot her, would have been confirmed in her belief. He had refused, for those reasons, to say it. He had stayed in prison for 48 years, 1 month, and 18 days. He had, in the final year before his release, not had any confidence that the release would come. He had expected, by the end, to die in custody. He had made peace with that expectation. And then, in July of 2023, an attorney with a records request he had been trying to file for years had received a document from a metal cabinet in a police station in a suburb of Oklahoma City. The document had been there the entire time. It had, across the 48 years of his sentence, never left the police station where it had been filed in 1975. It was the reason he had been in prison, and it was, finally, the reason he was allowed to walk out. The National Wrongful Conviction Record stands, as of this writing, at Glynn Simmons's 48 years, 1 month, and 18 days. It will, in all likelihood, be broken at some point in the future. American prisons hold, by the estimates of the Innocence Project and of the National Registry of Exonerations, thousands of people whose convictions would, if the evidence were re-examined, not survive. Some of those people have been inside for decades. Some of them will remain inside for longer than Glynn Simmons did. But the record that he set when he walked out into the Oklahoma afternoon in July of 2023 was not only the record of the duration of the wrongful sentence. It was the record of the duration of a single person's refusal. He had said no
to the parole board. He had said no to the investigators who had come to him over the decades with various forms of the deal. He had said no consistently for 48 years to any version of the lie that would have been required to release him earlier. The refusal had cost him most of a lifetime, but the refusal was, in the reckoning that came with his declaration of innocence, the single thing that had not been taken from him. He had kept it. He has, in the years since, continued to keep it. He is 72 years old as of this writing. He lives quietly. He is, by the formal finding of the state of Oklahoma, innocent. He always had been.